right. Good evening, everyone. Good evening and welcome to the Dole Institute. My name is Audrey Coleman. I'm the director, and it is such a pleasure to welcome you all this evening. This is our programming finale for spring of 2024, and it's been an extraordinary season, and this program tonight really represents some of what is the very best about the Dole Institute for so many reasons. Last Friday, we opened an exhibit in our Elizabeth Dole Gallery and Reading Room that features the work of our SAB coordinator, Ali Hagar. Tonight, we welcome and showcase so many talents of members of our Student Advisory Board here at the Institute. We're working again with our great friends, Ed Duckers and Pedro Irigonegaray. Welcome to all of you who might be representing Washburn and Washburn Law. Really excited to partner with you all this evening and showcase the talents of Washburn Law students as well, of course, as we honor the tradition of Bob Dole and our shared Bob Dole legacies. That is very special. I was doing a little research. Many of you I see in the audience have followed the Dole Institute and been supporters of us for many years. This program originated as a program called Neutral Ground in 2008, and it just so happens that in 2008, the moderator of that first Neutral Ground program was none other than Bill Curtis, who was our guest last week for the 20th Dole Lecture. So the Dole Institute has just some really amazing traditions. Interestingly enough, the topic that was discussed on that evening in 2008 was, the resolution was all U.S. combat forces should be withdrawn from Iraq by May 2010. So if that doesn't kind of take you back to how long it's been and to that point in time, that's just what I thought that would be a fun fact to share with you all. Again, I want to welcome our friends from Washburn. Really pleased and excited, and thank Pedro for his inspiration in connecting with you all for this program. Expert witnesses, thank you so much for your time and effort in being a part of this program. Students, again, great job. Sarah Stacy, thanks so much for all of your work coordinating this wonderful yet compliant group. I understand you've all behaved yourselves, but you all are in for a treat. Now I'm going to, again, thank you for being here at the Institute for our season finale, and I will turn it over to Braden Bangelin, who will be our moderator, and he will introduce the resolution for this evening. Braden, take it away.
Thank you, Audrey. Good evening, everyone, and welcome to the latest installment of The Counselors. The Counselors is a courtroom-style debate over an important issue. This year's program topic and resolution is resolved. Justices to the U.S. Supreme Court should be appointed for a single fixed 18-year term rather than a lifetime appointment. I will now introduce our participants. The affirmative case will be advocated by our counselor, Pedro Irigonegaray. Mr. Irigonegaray is an attorney and partner at Irigonegaray, Turney, and Revenaugh. The affirmative case's expert witnesses are Michael Milov-Cordoba, counsel in the Brennan Center's Judiciary Program, and Lou Mulligan, dean of the UMKC Law School. The university students involved in preparing this case are Sarah Vargas, a second-year law student at Washburn University School of Law, and Riley Keeter, a KU junior and student advisory board member. The negative case tonight will be argued by Counselor Ed Duckers. Mr. Duckers is a partner at Stoll Rives LLP and the head of the firm's litigation practice in California, as well as this members of the firm's executive committee. The negative case's expert witnesses are Stephen McAllister, the E.S. and Tom Hampton Distinguished Professor at the KU School of Law, and Shannon Grammel, counsel at the Lahotsky Keller Cohn LLP. The university students involved in preparing this negative case tonight are Caitlin Riffer, a third-year law student at Washburn University School of Law and former student advisory board member, Nathan Binstock, a KU freshman and SAB member majoring in economics on a pre-law track, and Jaspreet Kaur, a KU freshman and SAB member majoring in communications. The rules of the counselors are as follows. Each counselor will present their case and must follow the time constraints for each set of arguments and cross-examination of the witnesses. We have our timekeepers on both sides who will hold up their cards letting each side know how long they have left for their time. First, each side will have 5 minutes of their opening statements. First with the affirmative case with Mr. Irigonegaray, and next with the negative case, Counselor Ed Duckers. Next, each counselor will have 24 minutes to ask their expert witnesses questions to build their case. First the affirmative and then the negative case. During this cross-examination time, the opposing counsel will have 16 minutes in total to cross-examine the opposing side's expert witnesses. They may choose to split this time up however they would like, and the timekeepers will let them know how much time they have left. Lastly, after this cross-examination period, each counselor will have 5 minutes for their closing statements. Counselors, when your time is up, please conclude your speech in a timely manner. Now, without further ado, we will begin with the program. I welcome Mr. Irigonegaray from the affirmative case to make his opening statements.
I appreciate your presence. My opponent, Ed Duckers, is a dear friend, and we hope that this program will be educational and enlightening. Our side is the affirmative side. We believe, and we hope to convince you, that Supreme Court justices of the United States should be term limited to a period of 18 years. And there are many reasons for doing so. Today's Supreme Court has assumed a degree of power and importance that would have been unrecognizable in the founding era. A recent cascade of ethics scandals has laid bare a system in which justices wield tremendous power for decades with little accountability. While the court rulings are increasingly unmoored from domestic values and the principle of judicial restraint. At the same time, polarization among the political parties and the justices themselves has dramatically increased the partisan stakes of the confirmation process, leading to a broken system. Public trust in our courts is at an all-time low. These are some of the reasons for which we believe it is important to have term limits. How we go about it, it can either be done statutorily or with a constitutional amendment. The constitutional amendment process is going to take longer. Statutorily, it can be done. The reforms that we're going to suggest to you in this program can be implemented by statute. Doing so, consistent with the Constitution's text and structure, with the ways in which Congress has previously regulated the courts, including the existing system of senior judges and with the values of judicial independence that animate Article 3 and its good behavior clause. Now, our program will have two witnesses. The first witness is Mike Milov Cordova. Mike is from the Brennan Center of Justice. He has a doctor's degree in law from New York University, a master's degree from Columbia, and an undergraduate degree from Amherst. He will be questioned by Ms. Sarah Vargas, and Mike will provide the reasons for the change. The way we have structured our argument, Mike will present the reasons, and our second witness, a dear friend of many years, who's a dean at the University of Missouri School of Law in Kansas City. Dean Mulligan, Lou Mulligan, is a highly respected legal author. In 2022, his legal writings were cited in more than 80 occasions by federal and state courts. He is a highly respected, knowledgeable individual, specifically in the area of civil procedure. Dean Mulligan will be questioned by my co-counsel, Riley Lynn Kiter, a student here in the undergraduate program at the University of Kansas. There are a number of reasons for which we need change. Ethics, individuals that become part of the court, some in excess of 30 years. I believe it is important to bring vitality, to bring new ideas, to accommodate our ever-changing society. And the many reasons that you will hear tonight, I believe, will be compelling to you in the desire to modify the way our Supreme Court justices are currently serving and apply a system in which, after an 18-year term, they will simply step aside and become involved in a different manner with the court. Thank you for your attention. Welcome to the Dole Institute.
Thank you, Mr. Irigonegaray. Mr. Duckers.
Thank you, Your Honor. I join with Pedro in thanking you all for attending, and I think this is our 15th year together doing this program, and every one of them is a joy. And the students that we have this year doing the direct and cross examinations have just been outstanding, and I think you're really going to enjoy that. You know, our founding fathers were quite genius in forming a democratic republic with three equal yet separate branches of government: the legislature that makes the laws, the executive that enforces the law, and the judiciary that interprets the law. Now, two of those are political, the executive and the legislative, but the judiciary is not. The role of the Supreme Court and the role of the judiciary is not to swing with the tides of public opinion, but rather to determine from the words on the page and from the intent of the legislators and the drafters what the law is. To the greatest extent possible, our founders sought to ensure the independence of the Supreme Court and the judiciary from the political pressures of the executive branch and the legislative branch. And one of the major ways that they did that was through life tenure, to ensure that justices, once appointed, could serve for life and evolve for life in terms of their judicial philosophy. Professor McAllister will be our first expert, and he will explain to you the framers' intent and also explain to you why this is beneficial to every single one of us in having this relative certainty on a Supreme Court. He will also touch on the unwanted and unanticipated consequences of this term limit proposal. Professor McAllister clerked for Justice Whizzer White, and then he clerked for Justice Clarence Thomas many years ago. Our other expert, Shannon Grimmel, clerked for Justice Brett Kavanaugh. They both today continue to practice as Supreme Court lawyers, which is the highest and most rarefied era of the legal practice. They are the lawyers to whom you turn when a case is going up to the Supreme Court or being heard in the Supreme Court. And they are going to tell you from actual experience on the court, not wishful thinking, what the consequences would be of imposing term limits. For example, if you are concerned, as my friend just raised, about ethics and the influence of outside influences influencing the Supreme Court, understand term limits would make that worse. Term limits would increase the exposure of retiring justices to outside influence who might seek to employ them or regain them. They are unlikely to take senior status. Judges today who voluntarily retire, or justices because they want to slow down or do something else, often take senior status. But terming someone out of office in their early 60s up to their mid-70s involuntarily is an entirely different matter. Lawyers are very often in their absolute prime from their mid-60s to their mid-70s. At least that's what Pedro and I think. But it is true. It is the wisdom and experience that clients value, and a Supreme Court justice forced out of office by an arbitrary term limit is going to have the world at his feet seeking to provide employment opportunities. And speaking of experience and wisdom, one cannot possibly contend that replacing experience and the wisdom that grows from it with inexperienced ideologues simply to fulfill a term limit commitment is going to make the court better. And in fact, you don't need to look any further than the recent Dobbs decision to realize that, where the three newest members of the court joined the minority rather than the concurrence of the experienced justice, Chief Justice John Roberts. And that is what you would be trading that sort of wisdom and experience and moderation for extremism and ideologues, excuse me, with a term limit proposal. They'll also point out many more defects in this proposal. And Professor McAllister will also tell you that this cannot be done statutorily, as Dean Mulligan suggests. It would have to be done constitutionally. It's probably not even worth talking about doing it statutorily, because that statute would go right up to the Supreme Court and be ruled unconstitutional. But you should hope with every fiber of your being that Supreme Court terms and the advice and consent process of the Senate and all of these things cannot be changed statutorily, because what one Congress can do, another Congress can undo. What you like today in a proposal that's being advanced can be savaged tomorrow by a new Congress and president, and that will not restore any sense of legitimacy in the eyes of the public. Thank you.
Thank you, Mr. Duggars. We will now begin the affirmative case. You may present your case, Counselor.
Mr. Cordova. Oh, thank you for taking the time to be here today. My name is Sarah Vargas, and I will be the first counselor examining you today. Now, I want to begin with, why do you believe the United States Supreme Court would benefit from adopting an 18-year term limit system?
So I think your question was, why would 18-year term limits, why is it a good idea?
Yes.
So it's my view that a system of 18-year term limits coupled with regular appointments to the Supreme Court would strengthen the court as an institution and promote good governance more broadly. As folks in this room probably know, sort of Civics 101, checks and balances are a critical component of our constitutional order, and they run to each of the branches of government. They ensure that no individual governmental actor, no group of persons, and no branch of government accumulates too much power over citizens. It's my view that over the course of the last several decades, the Supreme Court has, in a variety of ways, insulated itself from some of the checks and balances of our constitutional order. The first is tenure. Supreme Court justices in the modern era are serving much longer terms than they were previously. The second involves strategic retirements. So this is the idea that Supreme Court justices are increasingly timing their retirement so that presidents of a certain party appoint their successor. The idea is to prolong the jurisprudential or ideological position of the justice long after they've left the bench. The third way in which Supreme Court justices and the Supreme Court generally are evading checks and balances is through the appointment process. In the modern era, we see increasingly more presidential terms in which presidents have no opportunities to appoint Supreme Court justices, while other presidents during their presidential term have multiple opportunities to appoint Supreme Court justices. The appointment power is one of the major ways in which the other branches of government act as a check and balance against the Supreme Court. And so to frustrate that is to frustrate the checks and balances on the court. And then finally, as Pedro mentioned earlier, the confirmation process is broken. And so to restore good governance, it's my view that term limits, by reducing the stakes of any individual vacancy on the court, would turn down the temperature politically and improve the confirmation process.
Thank you. Now, let's look at each one of those reasons more closely. Can you describe the changes that have occurred over the last 50 years regarding tenure for Supreme Court justices?
Sure, absolutely. So with respect to excessively long terms, historically, Supreme Court justices serve for about 16 years. That number began to balloon beginning in the 1970s. Since then, the average tenure of a Supreme Court justice is something close to 26 years. And current studies have shown that, or studies project that justices recently appointed to the bench may serve for upwards of 35 years. That's nearly 9 presidential terms. That's a long time to be wielding the amount of power that a Supreme Court justice wields. And with respect to strategic retirements, there too we're seeing a development in the modern era. Justices are increasingly retiring to ensure that presidents of a certain political ideology appoint their successor. That's not how the founders envisioned this system working.
And can you explain further the dangers that occur with excessively long terms and justices strategically retiring?
Sure. So with respect to excessively long terms, at kind of a basic level, there's a risk that justices will stay on their bench well past their prime, to the point where they're experiencing physical or cognitive decline that makes it difficult for them to fulfill their duties as a Supreme Court justice. Unfortunately, we have seen this occur in the modern era. The most notable example, or well-known example, is Justice Douglas, who unfortunately suffered a severe stroke toward the end of his term. And while he did retire not too long after suffering that stroke, this was largely because the justices on the court sort of forced his hand by threatening to sideline him from opinion writing unless he accepted the fact that he was no longer able to function and retired. Additionally, with respect to excessive terms, there's a real risk that by simply being isolated from the normal currents of life for so many years, justices have impaired, their decision-making is in some way impaired. And this is not just my view. I mean, Chief Justice Roberts, when he was a White House attorney, wrote a memo supporting Supreme Court term limits. And in that memo, he said 2 things. He said, first, when the framers wrote the Constitution, they weren't thinking that judges or justices were going to serve 20, 25, 30 years, because lifespans were just not that long at the time that they wrote the Constitution. But more importantly, and more to the point, he said that justices being removed from, or something to the effect of, justices being removed from the ordinary currents of life in a kind of ivory tower existence is, there's a chance that impedes their ability to decide cases. In other words, to that removal from the impact of their decisions for so many years impairs their decision making.
And how would 18-year term limits fix these issues?
So it's pretty straightforwardly. I mean, so with justices under this proposal would be appointed to the Supreme Court every 2 years and serve for 18-year terms. After serving for 18 years, justices would serve out the remainder of their life term in senior status, operating in much the same way that retired Supreme Court justices currently operate under the status quo. With respect to strategic retirements, a system of 18-year term limits would also solve that problem. There are ways to structure 18-year term limits such that if a Supreme Court justice, were to retire early or unexpectedly die while in office, it would not be the president that gets an additional appointment to the court, as we've seen in recent years, but instead the most recently elevated senior justice would resume active service and continue to operate as an active service justice until that vacancy was scheduled to be filled. It would bring regular order to fulfilling to the appointment process and really prevent the kinds of gamesmanship we've seen when it comes to strategic retirements.
And earlier, you described the confirmation and appointment process as a broken system. Can you explain what you mean by this?
Sure. So with respect to appointments, I mentioned this briefly, but in the modern era, we've seen a kind of wide variation in the number of appointments that occur during a presidential term. Sometimes that number has been 0, and it's been upwards of 4 in other administrations. This is unusual because historically, the number of appointments that have occurred during each presidential term has been 2, which is the number that would accompany 18-year term limits under the proposal at issue. With respect to the confirmation process, I think people on both sides of the aisle would agree that the status quo is untenable. We've seen senators engage in aggressive acts of constitutional hardball to either rush to fill a seat or to prevent a president from filling a seat that occurs during their term.
And how would the 18-year term system fix this problem?
Well, on appointments, each president would get 2 and no more than 2 appointments to the court per presidential term. This would ensure fairness across administrations. It would ensure that in the event of an unexpected vacancy, a president would not get an additional appointment. Instead, as I mentioned, the most recently elevated senior justice would resume active service until the appointment was scheduled to be filled. On the confirmation side, look, it would be the case that under this proposal, confirmations, Supreme Court confirmations that is, would be more common. They would be more frequent. But it's my view that part of what's driving the dysfunction in Washington over Supreme Court term limits is because the stakes are so high. And the reason they're so high is because of life tenure. When senators are not sure, the reality is that under the current system, justices are either retiring when their favorite president is in power, or they're dying in office. Senators there are few opportunities for senators, and they don't know when those opportunities will occur for them to obtain a partisan advantage on the court. And the confirmation process under the proposal at the 18-year term limits would really reduce the stakes of any individual vacancy because there would be regular turnover on the court, such that senators would be less incentivized to really duke it out for every vacancy on the court.
Thank you. And currently, Republicans have an advantage on the court. Why should we view this as a good governance policy rather than a power grab by the Democratic Party?
No, I really believe this is a good governance policy at its heart. This is a proposal that does not give one party or another on its face a partisan advantage on the court. The party that wins national elections will get a reasonable number of seats per presidential term under this proposal. In addition, sorry, I have a little more time, so 2 other points. There's a broad scholarly consensus that term limits make sense. In 2020, the National Constitution Center convened groups of scholars, progressives on one side, conservatives on the other, to write their ideal constitutions. And wouldn't you know it, both sides included 18-year term limits for Supreme Court justices. There's a strong scholarly consensus that this is a reasonable thing to do. And then finally, it's a popular proposal. I mean, very few proposals these days poll above water across parties, and Supreme Court term limits is one of them. Since about 2014, when this is as far back as I've been able to find polling on this issue, somewhere between 60 and 70% of Americans voice support for a fixed 18-year term for Supreme Court justices. And that, importantly, that's majorities of Democrats, that's majorities of independents, and that's majorities of Republicans. And that hasn't changed as the composition of the court has changed. So, really, Americans view this not in partisan terms. They view this as a good government proposal. It's politicians that see this as a partisan proposal.
Excellent. Thank you, Mr. Cordova.
Sure.
The affirmative is resting.
Mr. Duckers, it is now your time to cross-examine.
Caitlin?
Good evening. My name is Caitlin Riffer, and I will be cross-examining you. I'd like to begin where you ended off, that this is a policy proposition that's relatively recent.
The proposal for Supreme Court term limits?
Yes.
I don't know how recent. I think this is something that folks have been interested in the academy for a number of years. But we have had bills in Congress to implement this more recently, yes.
And so we're certainly at a boiling point for this issue in 2024.
Sure, I would argue that, yeah.
like to discuss your employment. You're currently employed at the Brennan Institute,
The Brennan Center for Justice, yes.
and this is dedicated to Justice William Brennan.
Yes, I believe it was founded by a group of his former clerks and his family.
Justice William Brennan is widely regarded as one of the more liberal justices on the Supreme Court.
That's true.
And he served his term on the Supreme Court for 34 years.
That's too long.
You say a 26-year average is where we're at right now.
I believe that's correct. It depends on the year you're sort of using to start that average, but I think if you take it from 1970 on, it's 26 years.
And so under your proposal, Justice Brennan would have been termed out in October 1974.
I assume your math's right, but yes, I don't know when he was appointed.
And he would have been potentially replaced by President Gerald Ford, correct?
That sounds right.
And in 1974, no one was suggesting that Justice William Brennan should be replaced by Gerald Ford, correct?
I'm not aware of anyone, no.
Yet today you would suggest that replacement,
Yes.
despite some of the value in legal analysis that Justice Brennan contributed later in his career.
I would. I mean, I don't deny that there are certain justices that have the cognitive capability to continue serving past 18 years. But this proposal is not just about preventing the worst case scenario of a justice not being able to perform their job. It's really about bringing fairness to the confirmation process, realigning the court with the democratic process. I'm not advocating that we vote for Supreme Court justices. That would be a terrible idea. But there needs to be some basic connection between the democratic process and the composition of the court. And that's laid out in the Constitution. I mean, that's part of what the appointment power is about. It's not, justices should not be able to.
I'll stop you there, but so you would agree that Justice Brennan had some valuable contributions later on in his career, correct?
Certainly.
And so other than Justice Douglas, what would be some justices who had cognitive decline well past this 26-year mark?
I believe I don't know how long Justice Black served, but it's my recollection that he suffered from memory lapses late in his term. I believe Justice Marshall, there's stories from some of his clerks as well. Arguably, it's hard to know from the outside, but certainly from the outside, the physical decline of Justice Ginsburg was quite apparent to anybody who was watching the court. And so even if in the event that justices, that justices can continue to do their job, the appearance that a justice is struggling to do their job also is not good for the legitimacy of the court. And so 18-year terms hedges against those outcomes.
And so overall, it would be your conclusion that replacing years of experience with newer, younger justices would be net better for the court?
I do, because the status quo is so untenable. I mean, it's not a good system that justices are playing such an active role in the selection of their successor. That's not how the Constitution was written. The founders were very nervous about unilateral generational power, and they put a lot in the Constitution to prevent that from happening. The idea that justices can time their retirements to ensure that either a conservative or liberal president gets to appoint their successor, it's really contrary to the spirit of the Constitution. And indeed, we're seeing, in some cases, justices acting more aggressively. I mean, this is reporting, but it was reported that Justice Kennedy reportedly lobbied President Trump to include then Judge Kavanaugh's name on his short list of Supreme Court nominees.
We'll talk about Kennedy in a moment, but I would like to refer back to the problem that we're addressing. You state that the solution you impose would have us at 2 appointments per presidential term.
Correct.
Yet you testified to that historically appointments have already set at about an average of 2 a term.
Historically, yes. But there have been different numbers per presidential term. I mean, since 1970, there have been 4 presidential terms with 0 appointments to the court.
But
prior
overall,
to 1970, that number, if you take all of history up until 1970, that number is 5. So there's a huge increase in the number of presidents who don't get an appointment to the court since 1970.
But overall, it still averages out to about 2 a term in the current system.
Yeah, and so in that way, this proposal simply formalizes what's happening informally, and while imbuing that process with fairness.
And then before we move on to the Kennedy point, I'd like to just get a little bit of an answer on your math there. So with 9 justices and appointments every 2 terms, your solution to fixing that is the senior judge at the end when, if we end up, 8 years down the line with an odd number?
Sorry, I don't quite follow the question.
So 9 justices on the court and an even 2 every presidential term
Yes.
likely leaves us with an odd one out at the end of an 8-year term. So your solution to that is the senior justice?
As justices serve 18 years, after they serve 18 years, they would be moved to senior status. If a president were to win one election and then another, they would have 2 appointments in their first term and 2 appointments in their second term. I'm sort of struggling to understand the question.
So then in the next presidency, there would be another 4 appointed, correct?
If it was a 2-term president, yes.
And then that 9th justice
Yeah.
that sits on the court would still be assigned to the president next, in the next 8-year
The
term.
9th justice, yeah, they would be the next one replaced during the next presidential term.
Okay, thank you. Now, I'd like to move on to the notion of strategic retirement. You base this notion in strategic retirement largely off of Justice Kennedy's retirement, yes?
No, that's not correct. That's the most egregious form of gamesmanship among the appointment process that we've seen. But the reality is that when you look at the recent justices retiring, I mean, it's pretty consistent that liberal justices retire under liberal presidents and conservative justices retire under conservative presidents.
Yet Justice Kennedy was widely regarded as a centrist on the court as well.
By some folks, yes, he was a moderate, but appointed by a Republican.
And then to have stepped down during a Republican's term.
Correct.
So I'd like to get to my final point. You would agree that continuity is valuable in constitutional analysis overall.
Definitely, yeah.
And that part of the issue that we're bringing up is that Dobbs and potentially this current court could overturn over 50 years of precedent that the courts have been setting.
That's certainly a concern of mine, but I view this policy its policy is not an outcome determinative policy. If Republicans win elections, they get to keep appointing, justices to the court. The policy itself is not about the outcomes of the court. It's about realigning the composition of the court with the democratic process broadly. Again, we're not electing justices.
Yet this policy makes the judiciary a voting issue in every election from here on out.
Well, I would argue it already is, and part of the reason it already is because you could have the stakes are so high when there are life seats. I mean, when it appears to voters that there's a once in a lifetime opportunity to pack the court for a generation or two, that politicizes the issue, I would argue, more than the notion that every president gets 2 appointments.
But then we'll be aware of the ideology of every president or every judiciary nominee appointed under this policy.
I think advocacy groups are already doing that job for us on both sides, liberal and conservative. There's a lot of vetting happening on both sides right now. I would argue that advocacy groups under the proposal that we are discussing it would in some ways be less incentivized to really duke it out because again, there would no longer be the promise of multi-generational power. There would be regular appointments to the court. The court, there may be swings in the court, but the notion that you could appoint 3 lifetime justices over a very short period of time and lock in a majority, conservative or liberal, it would just not be part of politics anymore.
But really this proposes that one party gets to appoint in one election.
Correct. I mean, you still have to go through the confirmation process. The president would nominate and the Senate would confirm.
And the next after that.
Yeah.
No further questions.
Thank you, Mr. Milov Cordova. We will now hear from the affirmative's second witness. Counselor.
I'll be asking you some questions today, and the first one is, could a system like our witness described be adopted by the United States through a constitutional amendment?
Yes. In the United States, we can amend the Constitution to change almost anything except for the composition of the Senate itself under Article 5 with a 2/3 vote of both houses and with 3/4 of the states ratifying that amendment. So we could, it would be a challenging political process to be sure, but we could amend the Constitution to adopt an 18-year junior and senior holding of office position by constitutional amendment.
And have any other countries implemented term limits for high court justices as well?
Indeed, they have. If you were to survey Western democracies, you would find we are the only nation to have a high court, depending on the name of it, with a lifetime appointment. Even our kissing cousin countries, such as Canada, will have limitations, whether it's by term or by age or otherwise, on their high court. And I dare say you would not claim that those nations lack judicial independence. The Canadian Supreme Court, for example, is quite known for exercising independent judgment under the Canadian Constitution, despite the fact that they don't have lifetime appointments. So this is a quite common process. Indeed, the longest term you would find if you were surveying across the world would be with the German Constitutional Court of 15 years. So this proposal would be 20% again more than that longest serving courts in Germany.
And how do our U.S. states handle tenure of state Supreme Court justices?
Again, you will find a consensus. 49 out of the 50 states do not. 49 out of the 50 states do not have lifetime appointments to their state Supreme Court. Only Rhode Island would have a lifetime appointment to the state Supreme Court. You'll find any number of limitations, whether it's age, some sort of electoral check, some sort of term limit. And I'm quite sure that folks that observe our state Supreme Courts would agree that those courts exercise judgment that's protected and independent of the political branches. One does not have to be a scholar of recent Kansas history to know that our Supreme Court here in Kansas, despite the fact of those justices not sitting for life, has exercised independent political judgment time and time again, much to the consternation of folks in the State House. They did not need that lifetime appointment to have that essential component of judicial independence and to exercise it fairly.
It is legally uncontroversial that Supreme Court term limits could be adopted by constitutional amendment. Could they be adopted by statute without running afoul of the Constitution?
We believe that it could. We believe that you could have a process by statute where a justice would hold his or her office in a junior and senior capacity, one unified office. They would hold that junior and senior capacity for life, staying in the junior capacity or active capacity, if you like, for 18 years and moving to senior status after that, holding that for life, constitutionally and doing so by statute. That ultimately boils down to three broad points in order to achieve that. So the first question would be, does Congress have the authority to regularize appointments such that each president would have 2 Supreme Courts, and can they do that by statute? The answer is unequivocally yes. Congress can change the number of Supreme Court justices tomorrow if it wants to. Does Congress have the authority to require a justice to take a senior status role? And the answer to that is, again, yes. Congress can assign duties or lighten duties by statute to any member of the judiciary. The Supreme Court has answered that question. And 3, would this somehow offend the ability to hold an office under good behavior, as that phrase is used in Article 3 of the Constitution? And the answer to that is, again, No, it would not. This is not a changing of the office, but a changing of duties assigned to that office.
Could you elaborate on your first point regarding Congress's constitutional authority to set a regular schedule for Supreme Court appointments?
Absolutely. This starts with the text of Article 3 of the Constitution. Despite the fact in the last few decades we've had 9 justices on the Supreme Court, the Constitution does not demand that there be 9 justices. Indeed, over the course of our history, we've had several different numbers of justices appointed by statute. It's been as large as 10, small as 6, passed by statute. So the ability for Congress to say, these are how many seats we have on the court, this is when a new seat opens, is a actually mundane question of, can Congress make the Supreme Court tomorrow 10 people, 11 people? Could it make it 5? Yes, yes, and yes. Would anyone argue opposite that? No. Could Congress, instead of doing it one statute at a time, create a system where this happens by operation of law automatically? Sure, absolutely. Congress retains that power over the numbers of seats on the Supreme Court. That is an unequivocal, unarguable, vanilla, bland, whatever word you like for mundane, proposition of constitutional law.
And regarding your second point, could you explain Congress's authority to require justices to take senior status after 18 years of service on the court?
Yeah, I'll be happy to talk about that. Let me first start with a little bit of history. Congress has always retained control over the type of work that Supreme Court justices do. So, pardon me, for decades, by statute, Congress required Supreme Court justices to sit on the circuit courts. And they had to ride circuit. The justices hated that. Back in the day, they had to leave Washington, D.C., on horseback and go hear cases in lower courts by statute and sit as circuit judges. The Supreme Court of the United States heard a constitutional challenge to that in 1803. And in a very short opinion, they said, yeah, Congress can make us sit on the lower courts. Congress can change our workload, right? That is quite straightforward from a matter of constitutional law. The second part of this analysis is, can Congress change the workload? Could they require you to sit on a circuit court, or could they change that over time? And of course, they can change it over time. The Supreme Court has answered that question as well in a case called Booth versus the United States about 100 years or so ago. The direct question there was whether a judge who held senior status still counted as a judge. Did that judge still hold his office? Yes. And the court said Congress can lighten the workload of a judge without removing him or her from office. So this notion that the particular workload is immune from the check and balance of the legislature just is not the case. And indeed, we've been doing this active senior judge status for quite some time in statute today. So 28 U.S.C. 294 allows for justices to take the status of senior justice. Justice O'Connor, for example, when she took senior status, heard cases on the circuit courts of appeals all the time, as did Justice Souter, under statute that everyone thinks is constitutional. Our lower court judges do the same under a sister statute of 28 U.S.C. 371. So these powers emanate from either the necessary and proper clause in the Constitution and or Congress's ability to create exceptions and regulations for the appellate power of the Supreme Court under Article 3, Section 2.
Wonderful. And touching on your last point, could you explain why 18-year terms would not conflict with Article 3 of the Constitution?
Absolutely, and I think part of it, terms and terminology here is important. The proposal here by statute would not have a term per se. After 18 years, that member does not cease to be a Supreme Court justice. Rather, she becomes a senior Supreme Court justice. She does not leave office exactly as the Supreme Court held in Booth. She remains in office despite having senior status. But Congress can change that person's workload. And that senior justice then could be assigned to sit on the circuit courts, to hear cases in original jurisdiction at the Supreme Court of the United States, to help with judicial administration, to work in the Office of Administrative Courts. All the things that statute today, absolutely, in which we all agree is constitutional, absolutely has senior justices and senior judges do. So it would not be a term limit per se, but rather a changing of the workload within one continuous term, within one continuous holding of office.
Thank you, Dean Mulligan. Those are all the questions I have for you today.
Thank you.
Mr. Duckers, you may now begin the cross-examination of the affirmative second witness.
Good evening, Dean Mulligan. So you testified today that term limits could be adopted by Congress through statute.
The testimony I gave was that Congress has the power to lighten or alter workload within one continuous term and to assign someone to senior status by statute.
Yes, but with any such statute, the Supreme Court would have the opportunity to assess its constitutionality.
Of course.
Yes. And you would agree that if the court struck down these term limits, it could be perceived as protecting their own interests?
I'm not an expert on political opinion, but I don't know how that would be especially different from any case in which the Supreme Court struck down a matter of the judiciary. The Supreme Court of the United States has heard cases about the power to impeach a judge. It had no problems getting involved in the U.S. versus Nixon case on hearing one of their own, and we didn't cry foul over the impeachment power. That the Supreme Court of the United States heard that all cases go to the U.S. Supreme Court if they're within federal jurisdiction.
Yes, but Dean Mulligan, wouldn't you agree that it's almost inevitable it would be deemed unconstitutional?
No.
No.
I think that was the thrust of my testimony.
Similarly, couldn't Congress still require significant support for the affirmative proposal in order to pass it through statute? So you spoke about how Congress could change the size of the court. So wouldn't this similarly require a significant amount of support within Congress to change term limits?
Again, I'm not proposing term limits, but rather that within one continuous holding of office that someone might take a senior status position by statute. If your question is it challenging to pass federal statutes, yeah. One has to go through the House and through the Senate. The president would have to sign that. Passing federal law requires political willpower and the spending of political capital, to be sure.
And this has been attempted in terms of changing the size of the court before, correct?
It has.
And there was concerns with, for example, FDR's court packing plan in 1937 that Congress or the president could push further legislation on similar topics that could similarly change the composition of the court. Is that correct?
So if we're talking about the FDR court packing plan of the 1930s, that's a very different proposition in which you had a president saying, I want to expand the size of the court and give all of those appointments to myself. The proposal here is that a president would have 2 appointments per term going back to the people for election, that the people would have that opportunity to vote in each election with the check of advice and consent of the Senate. This is a very different proposition.
But Dean Mulligan, that was a yes or no question. Could they pass further legislation?
Who's they?
as in Congress or the president? Is that a concern?
President can't pass legislation.
Could they push further legislation?
I don't know. What do you mean by pushing legislation?
So what I mean is, aren't there concerns that each party could repeatedly increase the size of the court or change the composition of the court in an attempt to gain control?
If your question is, if we pass a statute, could there be a new statute? Sure.
So do you not believe that that is an issue that would not destabilize the court with these constant proposals swinging its composition back and forth?
I don't think I'm advocating for a proposition of constant proposals of changing the size of the court back and forth. And
but is this not an inevitable result of these statutes?
No. Indeed, the point of this proposal would be that every president would have two, and that we would lower the temperature, and that each president would have two appointments subject to advice and consent of the Senate. And that would create a stabilizing and calming effect upon putting folks onto the Supreme Court.
So you do not believe any further legislation would be pursued or any further statutes?
You're asking me whether Congress in the future will pass statutes.
In terms of, yes. Under this context that changes the composition of the court?
You're asking me a crystal ball question about future Congresses in the future, and I'd imagine your guess is as good as mine, counsel.
So you also discussed state Supreme Courts and how they have a very different system. Mm-hmm. And you would say they're an example of where term limits function well?
The point I was making discussing our state Supreme Courts.
Is that a yes or no? Do they function well?
Do our state Supreme Courts function
yes.
well? I think our state Supreme Courts function very well.
But do they not have much more partisan influence within their courts? Many Supreme Court justices within states are directly elected. Is that not true?
Some are, and some are not.
And this creates significant partisan influence.
Based on what foundation for that question? I would look to our own state Supreme Court that uses the Missouri plan and has been a very calming effect on our state Supreme Court and has in no way impacted the independence of this court. I think it would be hard-pressed to read the last 5 years worth of newspapers in our state and believe that our state court does not exercise incredible political independence.
Dean Mulligan, in states like Iowa and North Carolina, weren't rulings from just a few months before on abortion, for example, weren't they completely overturned due to some partisan influences within the court?
Completely overturned by whom?
In terms of aren't decisions within state courts more often overturned?
Aren't state Supreme Court decisions more often overturned than the United States
yes.
Supreme Court decisions? That's a complicated question of whether we're talking about statutory questions or whether you're talking about state constitutions. State constitutions are generally more readily subject to amendment than the federal Constitution. So that's sort of an apples and water buffaloes comparison.
So then isn't that state system you use an example of where term limits had worked well, more partisan, less stable, and unpredictable?
I would disagree with every statement you just made, sir. Thank you.
Thank you, Mr. Mulligan. We will now hear from the negation's first witness. Mr. Deckers.
Professor McAllister. And Caitlin will be him.
Thank you.
Good evening, Professor McAllister. Could you please introduce yourself and your position?
I'm a professor at the KU Law School, and like some of the justices we're talking about, I've been there far longer than 18 years.
And what are your areas of expertise in your study?
Particularly constitutional law and civil rights law, federal, it all revolves around constitutional law.
And what are you here to testify to today?
How wrong my colleagues on the other side are.
And to do so, what material did you analyze?
I looked at the Constitution, of course, a bit at historical materials like the Federalist Papers and some writing about this kind of notion for term limits.
Were you able to ascertain a framer's intent for the from the legislative history?
Well, there seems to be a pretty strong consensus that at least the framers who spoke about it or wrote about it viewed the good behavior provision as a form of life tenure, which they wanted, because they were familiar with colonial era practices where state legislatures often appointed and had exercised a lot of control over state judges. They also argued it would be a way to attract better candidates to the judiciary.
In analyzing this framers' intent, why is the framers' intent so important to modern constitutional analysis?
Because it's important to the court. So it's always a piece of any analysis involving the Constitution. Obviously, justices vary in how much weight they put on it, but all justices would look at constitutional history.
And did you analyze any of the past opinions of the justices in your analysis?
You mean those whose tenures would have been cut short, or just, yes?
Those whose tenures would have been
Yes.
cut short?
Yes.
And what was the value of looking at those past opinions?
Well, it was interesting to look at who would have been termed out by the 18-year limit. And it's not just a modern phenomenon. I mean, Chief Justice Marshall, who probably did more to establish the legitimacy of the court and in some ways of the national government, served 34 years. So he would have been cut in half, basically, in his tenure. One of his colleagues, very influential, Justice Story, was over 30 years. Justice Harlan, the first, who wrote the famous Plessy dissent against separate but equal, would not have written that dissent. He'd have been termed out before that happened. So there are a number of historical examples, and I can also talk about modern examples.
Well, I'd like to start by talking about the constitutionality of the proposal as a whole. What was your overall conclusion as to the constitutionality of an 18-year term limit?
Well, I disagree with my colleagues that it would be constitutional. I think the framers understood the term to be life tenure. And unlike them, it sounds to me kind of like a nomenclature game. I mean, you're either a justice or you're not. And if you're a justice, you're doing the job of a justice. I think that's what the framers would have contemplated. So the notion you can say, well, when you retire, which usually suggests you're not working so much anymore, you're still a justice in a constitutional sense, I think is inaccurate. So that, I don't disagree, Congress can direct some of the duties and the cases that go to the court and so forth, but I don't think they can simply say, poof, your life tenure continues even though you no longer get to do any single part of the Supreme Court's business. At that point, you are very effectively and really no longer a Supreme Court justice, and I think that conflicts with Article 3. So it would take a constitutional amendment.
And practically, how do Article 2 and Article 3 interact on this issue to create a constitutional amendment?
Well, you've got the president's appointment power and Senate confirmation, and there's a lot we could talk about with confirmation process. I don't think regularizing it would necessarily make it any less controversial. But you have to understand what the framers did is they said, you're going to get life tenure, but we are going to put you through a sort of process to attain that position. And the system they created was the president appoints and the Senate has to confirm.
Is there a valid way to change this statutorily?
I don't think so.
And what would be some of the consequences if we had to turn to this constitutional amendment?
Well, it's proven very difficult to do. So we only have 27 amendments in 230 years, and 10 of those came right out of the gate in the Bill of Rights. So 17 amendments in over 200 years. It's a very difficult process, but the framers intended it for it not to be an easy thing to amend the Constitution.
Now, Professor McAllister, I'd like to discuss some of your opinions on the issues this creates with the separation of powers between the legislature and the courts. What would be the impact of giving the legislature this kind of power over judiciary appointments?
Well, this is where I strongly disagree with my colleagues. If you open this door and say this is something Congress can do, then I'm not sure there's anything Congress cannot do with respect to the Supreme Court. Maybe it can't reduce their salary because that's in Article 3. But it's 18 years today. It could be 4 years tomorrow. It could be 10 years. It could be all sorts of things because once it's open to Congress, if one party or the other gains control of Congress and the White House, they can restructure it however they want.
Would there be any limit to what could be changed under Article 3 legislatively after this?
I don't think so.
Now, I'd like to discuss some of your opinions regarding the talent and experience of justices under the current system. How would the 18-year term limit affect the service of some famous historical justices?
Well, I mentioned several. So Chief Justice Marshall would have been cut short. Some of his most famous opinions he would not have written. Justice Story would have been cut short. Justice Harlan would have been cut short. There are others. Maybe Chief Justice Taney would have been cut short. Maybe that would have been good. But I mean, there are a number it would have impacted.
In what areas of constitutional analysis would this have impacted the most?
Oh, I don't know if there is any area I can say it would have impacted the most, but it would have impacted things across the board. And in the modern era, it would probably impact potentially individual rights the most, because some of the most important decisions written by long-serving justices were in favor of expanded individual rights.
And so if this 18-year term limit were imposed on modern era justices, what would have been some of the most significant impacts?
Well, so you would have cut off Justice Brennan, you would have cut off Thurgood Marshall, you would have cut off the first woman, Sandra Day O'Connor, you would have cut off the second woman, Ruth Bader Ginsburg, you would have cut off Anthony Kennedy, and he would never have written Obergefell and other cases protecting gay and lesbian rights. So, you know, Justice Brennan, everything he wrote essentially was in favor of expanded individual rights. Justice Marshall, the same. You know, Justice O'Connor had important opinions. For example, she upheld the Michigan Law School affirmative action program, which the current court has recently overturned, but she wrote that opinion, which was very important at the time. Justice Ginsburg obviously had many important opinions, so all of them would have had a much more limited service and much less impact on the law. And if you're on the other side of the aisle, so I'm sort of talking about the liberal side, but you know, you would have cut off Justice Scalia, you would have cut off Justice Thomas, and I know there may be people who would favor that, but on the other hand, there are people who would not want to see that happen. And so if you're talking about a balanced proposal, you know, I think it hurts all around.
Overall, is there value to seniority and experience on the court in your experience?
My perception, certainly as a law clerk, was that there is. You know, that experience builds over time. They have a record. They've seen everything. Things are not necessarily new. They may come in a slightly different form, but they recognize them for what they are. And so I think there was a lot of value in having those long-serving members. I mean, my first year as a law clerk was Justice Brennan's last. My second year was Justice Marshall's last, but they were clearly towering, important figures inside the court. I worked for Justice White, who served 31 years. You know, and so I think, you know, Justice Brennan is a good example. I mean, he developed such a rapport with his colleagues, such high respect. I mean, he could sometimes, I think, put together majorities that others would not have, and that wouldn't have happened if he was cut off at 18 years.
I'd like to end on some of your opinions about judicial legitimacy and credibility with this proposal. How would the 18-year term limit affect judicial credibility?
Well, I don't know how much it would affect credibility. We'd have to see, but I think it certainly could. You know, if you're a justice, say, has served 15 years and you have certain issues you care about and they have not been going your way, and you've only got 3 years left, I could see it heightening the bomb throwing and the people saying more dramatic and aggressive things because they don't have much longer to talk about these issues in a public way, and that would undermine collegiality at the court for sure, which is something the court does value. I suspect it's still true, but I don't know how many justices I've heard say in the conference room, there's never a raised voice, there's never anger. We disagree about some very important things, but we get along. And I think the 18-year term limit with all that turnover would make it much harder to have that kind of collegiality at the court, which I think ultimately contributes to legitimacy.
And in the status quo, is legitimacy of the judiciary currently preserved?
Well, I mean, eye of the beholder. I don't think the court has fundamentally changed the way it operates. And, unlike one of my colleagues who suggested that maybe life behavior or life tenure is what is politicized the confirmation process, I actually think it was one issue starting in the 80s when there was a sense that there were justices who were not happy with Roe versus Wade. It might be subject to overturning. And so basically from Justice Scalia, actually it was Justice Bork, never a justice, Judge Bork, who was defeated. I think that's really the issue that has driven a lot of the confirmation fights. I'm not saying Dobbs is right, but Dobbs may or may not alter that confirmation process if that issue is not something people perceive to be in play any longer at the court. So I don't think life tenure is what gets the senators going. I think it's often one particular issue.
Thank you. No further questions?
Thank you, counsel.
Mr. McAllister, my name is Sarah, and I'll be asking you a couple of questions today. So I want to go back to something that you mentioned during testimony. So you talked about justices being cut off from their duties. But under the 18-year system that the affirmative side has proposed, it wouldn't necessarily cut off justices from their duties. They would simply be placed in a senior status or an inactive status. However, they would still retain multiple different types of duties within their lifetime tenure that would not be taken away from them. So how is going into inactive or senior status under the 18-year system equated to being cut off, even though...
Because you don't do anything a Supreme Court justice does. It'd be like me being assigned to teach junior high, and you can say, well, you still have tenure at KU, but you've got to teach junior high classes. I wouldn't view that as continuing in my tenured status.
But these justices would still be able to have trials in the lower courts as they did in the first 100 years of the court's existence. They'd be able to manage the judiciary and hear cases in the court's original jurisdiction. So how is that still being equated to being cut off?
Well, they're not doing anything a Supreme Court justice does. They don't get to vote on anything they care about. If they're in the courts of appeals, it's been ironic, and sometimes they've commented, they get reversed by their former colleagues. They're no longer in charge, and I doubt that any of them, very few, want to go try cases.
Okay, and we'll switch gears a little bit. So would you agree that presidential terms are appropriate for a democracy?
Of course.
Now, considering that they are appropriate for democracy, and considering how the current appointment and confirmation system is not working as the founders had intended, how the current projected average terms for Supreme Court justices is about 35 years, and how there are very high risks of justices suffering cognitive and physical decline over the years, in addition to losing democratic legitimacy, how would those concerns not be compelling reasons to have an 18-year term limit?
Because they've been part of the system for over 230 years, and the country has survived, and by and large, we've had, for most of that time at least, the most admired Supreme Court in the world.
Well, the 18-year term limit system would offer an opportunity to ensure accountability within the system. And not only that, but would also foster a Supreme Court that accurately reflects the evolving dynamics of the American society. And this, in turn, would prevent a couple of things, like strategic retirement, to prevent justices from prolonging their ideological influence on the court. And in addition to that, it would promote a more dynamic court that would align with contemporary societal values. So given that, how would adopting a system that promotes a more accurate reflection of American society not be a strong reason to want to move forward with it?
So I'll take that as a question. So, I mean, it basically sounds to me like you're suggesting we really ought to elect Supreme Court justices so that they're responsive to the current interests of the people. But that's what we do with the White House and the Congress. The court has always been different. And part of that difference is the independence that life tenure gives them. And justices also are not always what people anticipate when they're appointed. I mean, there are many instances of justices going in different directions from what the appointing president would have wanted from them. So I think the life tenure is an important protection on independence. Things that change that undermine the independence of the Supreme Court. And we have two branches that are already supposed to reflect the contemporary values of the American people.
Well, speaking about undermining, let's talk about the undermining of the principles of accountability in America. So if justices did engage in strategic retirements, which we have seen over the course of the Supreme Court history, would that be something that would undermine the principles of accountability?
It's just part of the system. I mean, I think what you'd be trading for under the 18-year plan is other kinds of gaming. So if you think that's gaming, well, you'd just be trading it for different things. For example, justices might still strategically retire based on who the last justice before them to retire was, so that person can serve until the next presidency. But you'd also have gaming in ways that I think would be very bad for the judiciary. In particular, if you're a circuit judge and you know every term there's going to be 2 Supreme Court openings, there would be an awful lot of posturing and behavior in the lower courts as people tried to put themselves in position to be one of the next nominees because they know when it's going to come. It already happens, but it would get a lot worse.
But isn't fairness important also in American society and politics?
Well, of course, but what I'm saying is the system your side is suggesting I don't think is any more fair, and it opens a whole lot of new potential problems and chaos.
How is offering each presidential term 2 appointments unfair when there are presidents in the past who have gotten 0 appointments?
That's life. You know, we don't always get to do what we want, but that's the importance of the life tenure.
So I'm going to ask you a series of questions. And would you agree that you'll limit your answer to yes or no?
I'll try.
Thank you. So does the Constitution explicitly mandate lifetime tenure for Supreme Court justices?
Yes.
Now, have constitutional underpinnings ever been subject to interpretation?
Of course.
And have there been justices that have served beyond 18 years?
Many.
And can age affect an individual's cognitive and physical abilities?
Not me.
Well.
Of course. Of course.
Well, are Supreme Court justices immune from this decline then?
No, but neither are presidents or members of Congress.
But you did agree that presidents did have term limits, right?
They do, but some are, at the time they're elected, may not be all there.
So what about Supreme Court justices once they get into
The court has a long tradition. I know Justice Douglas was mentioned. The court has a long tradition that I think has generally worked well of each justice decides when he or she is ready to go. The others, you know, they view themselves as 9 equals. They do not want to be making decisions about each other, and I don't think the Congress should be making decisions. You know, the state courts are a whole different business because over 70% of state court judges are elected. So that's a very different situation.
But what about the Supreme Court justices that have stayed on up until very unfortunate points in their health where they wouldn't be able to participate in the same way that they did maybe initially when they first joined the court?
Well, I think there's 2 things. One, the extreme examples of that are rare, Justice Douglas being one. You know, the second Justice Harlan was going blind, but he had a giant magnifying glass and clerks could read to him. So I think, you know, there are ways that's mitigated. They have these very capable law clerks, but the justice still has the power to make the decision.
No further questions. Thank you.
Thank you, Professor McAllister. We will now hear from the negation's second witness.
We'll be handling the direct examination.
Good evening. Could you please introduce yourself?
Sure, I'm Shannon Grammel.
And what is your educational background?
I graduated from Harvard College and then from Stanford Law School.
Could you please describe your work history?
Sure. After graduating law school, I clerked for 1 year on the Court of Appeals for the Fourth Circuit. I clerked for Judge J. Harvey Wilkinson III. The following year, I clerked on the U.S. Supreme Court for Justice Brett Kavanaugh in his first term on the court. After that, I went to a law firm in D.C., Latham & Watkins, and I worked in their U.S. Supreme Court and appellate practice for 2 years. Then I moved out here to Kansas. I served as a deputy SG for 1 year. And now I'm at a litigation boutique called Lahotsky Keller Cohn, where I am counsel.
So how does your knowledge and experience apply to today's topic?
Like Professor McAllister, I believe my 1 year on the court, I guess slightly less, gave me at least a little bit of insight into how the court operates and the way the justices interact with each other. Also, during my time at Latham & Watkins, this was when the President Biden had his council on Supreme Court reform. Part of that was a committee of practitioners, and I helped that committee of practitioners prepare their report. I was not on the committee. It does not reflect my opinion. I cannot speak to their opinion aside from the face of the report, but it's a topic I spent some time thinking about.
So did this lead you to form any conclusions on the resolution?
Yes, like Professor McAllister, I believe it would be a very bad idea.
So let's start out with that idea and that proposal. What would the constitutional foundation for their proposed changes be?
I don't think there is one.
So then how feasible would it be for the affirmative team's proposal to be implemented within the existing constitutional framework?
I don't think it could be.
Do you think it'd be possible to maintain a regular appointment schedule under their proposal?
I think it would be extraordinarily difficult. Folks could still strategically retire for various reasons, as Professor McAllister noted. I also think there's another big player in this whole equation who's been mentioned a few times today, and I think who may be the motivating factor in this proposal, and that is Congress. I think Congress can operate to jam up this system using tactics they've already used and we've already seen, and that I think has inspired some of this frustration. So I think, it's all good and nice to say that each president gets the opportunity to nominate 2 people. There is no guarantee that Congress is going to act on that nomination. There is no guarantee that Congress is going to affirm any of those nominations, is going to allow anyone to join the court. And I think the more predictable you make the system, the more regular it is, the easier it is to gain, because people know in 2 years something else is coming. With the next election, something else may be coming. So I believe greater predictability allows for more precise and strategic gamesmanship.
And this regular schedule, it would introduce more certainty, as you mentioned. Is that good for the court?
I think that a system that allows for certainty in this way, kind of motivated by reasons of wanting each party to have equal numbers on the court, wanting each president to have an equal opportunity, I think, like I said, I think that allows for more gamesmanship. In terms of the nomination process, I think you also have concerns, as Professor McAllister mentioned, with lower court judges who will be jockeying on a more predictable timetable for these sorts of positions. I think predictability can also hurt the legal practice before the court, because lawyers now will know every 2 years there's going to be a new justice. Depending on who the president is, how things are looking, they might be able to kind of pick their court in a more real sense than they've ever been able to.
So then how do you believe the implementation of the affirmative proposal would look like today?
I'm not entirely sure how it would work with the current court. I'm not totally familiar with all the specifics, but I think, assuming that the current justices would be able to serve out the kind of to the end of their current term of life tenure, this could take a really long time to actually see happen in practice. I mean, it could take a generation or 2. And I think in that time, as we've discussed, once Congress can kind of make these changes to the court with ease with just a majority vote, I think that really opens the floodgates. So who even knows whether the legislation would still be on the books at the time it would actually be phased in a real and full way.
Now, I'd like to move on to the political side of the proposal. What effects would term limits have on the independence of the court?
I think that term limits would only serve to further politicize the court. I think one of the easiest ways, at least in my eyes, I think one of the most powerful ways to look at it is we are now tying 2 Supreme Court seats to each presidential election. We've heard, presidential nominees talk about candidates before. It's nothing new. But we've never known that they were actually going to have an opportunity to put somebody on the court. I think if we know that each president's going to have 2 seats on the Supreme Court, that in effect, in practice, puts those seats up for election every 4 years. I think kind of crystallizing it in that way in the mind of the American public is only going to make the court look more political.
So then do you think this would change the behavior of the justices?
I do. And I think there are kind of 2 senses it could change the behavior of the justices, kind of in their work sense, kind of the outward-facing job as a justice, but also in the way they operate internally as a body. So starting with the first, I think, Professor McAllister noted that people might kind of be more willing to lob bombs toward the end of their career when they're knowing, they know they're out soon, they're out the door anyways. I also think even potentially sooner, if people know that every 2 years there's going to be a new justice, the court's composition can change pretty rapidly. I think justices might be a little more willing to try and get away with a little more in their opinions to kind of see how long it can last. If there's a sense that, in 4 years, 6 years, it's going to be overturned anyway because the composition is going to change, why not see what we can get out of it in the meantime? I think there's a risk of that. I think looking internally, sometimes I think we forget that these are 9 people. And right now, they know they have to work with each other for the rest of their lives. They eat lunch together, they have conferences together, they sit on the bench together. It's a small building, and they don't have a lot of colleagues. It's a pretty isolated life. So I think that knowledge keeps things civil in times when it might otherwise be a little difficult to keep things civil. I think you could see a kind of dial-up in the rhetoric of opinions toward the end of folks' terms if they know they don't have to work together that long. I think it could really hurt the functioning of the court as a body of colleagues.
Do you foresee any conflict stemming from partisan influences within the nomination process?
I think within the nomination process specifically, I think we already see some partisan difficulties with Congress. And I think, again, that really seems to be a lot of the motivation here is that there's frustration. And I understand why there's frustration with the way the appointments process has played out and the confirmation process has played out. This proposal doesn't fix that. And I think for the proposal to work in any real way, it would require that sort of fix, which would require a fix to advice and consent, which is opening a whole different floodgate of potential problems if we remove that check on judicial nominations.
Do you think there would be any effects on lower courts or the pool of nominees?
Yeah, absolutely. I think you would have more jockeying, again, on a more predictable schedule for positions on the Supreme Court. Lower court judges are never sure there's even going to be a chance for them to become a Supreme Court justice. It depends very much on circumstance and how elections play out and things that no one can really predict with any regularity. But if we know that every 2 years there's going to be a seat opening up, and if we know the presidency switches parties with regularity, there are going to be chances. And you hear judges being criticized because they have their eye on that seat. And because they have their eye on that seat, they're either potentially writing opinions that'll attract presidents to nominate them, or maybe they're writing opinions to avoid saying controversial things that the rule of law, would have them say. So I think you'd see a difference in the way they behave and a difference in the way they decide cases. And I really believe that would undermine the rule of law.
So public opinion polls have shown that favorable views of the Supreme Court has fallen to a historical low. Do you believe that the affirmative proposal would change this perception?
I don't. I think this would further politicize the court. And I get the sense that a lot of the frustration with the court, perhaps not all of it, but a large sense of frustration with the court is people don't like the court to do things that they don't like. And that proposal doesn't fix that. I think people would be satisfied with the court when it's doing things they like and it looks the way they want it to look. And I think the opposite would be true when it's not. So I think we're in a time where people pay more attention to the court. It's covered more on the news. So I think, I just don't think this would fix any of the problems.
So then what effect could term limits have on the rule of law?
Yeah, as I said, I think the rule of law, judges should be deciding cases based on the law and not on other external factors. We just spoke a little bit about how lower court judges may alter their behavior and their decision making in order to gain seats that they want. I think it's important to remember in this conversation that the vast, vast, vast majority of the cases never see the Supreme Court. They hear, 60, 65 cases a year. It's like 1% or 2% of the petitions they get. Most cases are decided by lower court judges. And when you have those judges acting in an increasingly political way, deciding cases based not on the law, but on personal ambition, in the vast majority of the cases, that's going to be the final word. I think the court, too, is going to potentially kind of step outside the bounds of what it should be considering. Judges or justices are going to step down. They know they've got new careers coming. They could change their behavior and decide cases in a way that positions them for their kind of post-judicial career, too.
Do you believe the court would still be insulated from the will of majority and public opinion?
I don't. As I mentioned before, I think this really, in a sense, puts Supreme Court seats up for election. And I think, one of the values of having a court that is specifically insulated from the public and is designed to be insulated from the public is that it protects those who are unpopular with the majority. That's the majority that elects Congress. That's the majority that elects the president. The U.S. Supreme Court is the only body that's not directly answering to that majority. And so it can protect groups who are unpopular with the majority.
Thank you, Ms. Gramel. No further questions.
Thank you.
Hello, Ms. Gramel. I'll be asking you some questions, and I'm going to ask that you respond with yes/no answers only. Is that satisfactory?
I'll do my best. I'm a lawyer, so.
Thank you so much. Would term limits promote greater judicial accountability by ensuring that justices regularly face reevaluation?
I think it depends. I think accountability to the public, probably, but that's not what the court was designed to be.
All right. Would establishing these term limits also prevent strategic retirement and political gamemanship?
No.
Do you still believe so, even as our system allows for a senior justice to be ready to assume the position as an active justice steps down?
I do not believe this would minimize gamesmanship. I just think it would provide a more specific timetable on which that gamesmanship would occur. I think you could still see, early retirements of someone who's kind of done and wants to do something else, but likes their colleague that just retired, so I'll step down, they can have it back for the remainder of my term. That could certainly happen. Supreme Court justices don't always stay on the court that long.
Thank you, Ms. Gramel. I don't mean to cut you off that often, but we have limited
Sure.
time. Would an implementation of a term limit absolutely require a constitutional amendment?
I believe so.
Is it true that Congress has the power to create and eliminate justice seats through statute as it has done so in the past?
Yes.
And yet you still believe that implementation would absolutely require an amendment?
This isn't creating a seat, it's imposing a term limit that doesn't exist in the Constitution.
And yet it is setting a regulatory standard for how the seats operate. Do you not think that is precedent for determining how the seats may be structured?
No, I think this would certainly require a constitutional amendment.
Do you believe that the term good behavior in Article 3 insinuates lifetime tenure?
I believe that's how it was understood, yes.
Would a plan that implements an active term of 18 years and then an inactive term to life therefore align with Article 3?
No, and I think the fact that you use different words to describe the terms bespeaks how different they are.
Where specifically in Article 3 does it address active tenure?
It says under good behavior. You can hold the office of a Supreme Court
But
justice.
at no point does it say active tenure, correct?
The role of a justice is an active justice on the Supreme Court.
Is that specifically outlined in the article as active?
The Constitution doesn't say everything that the whole body of constitutional law says.
Thank you, Ms. Gramel. Do you believe that when the framers wrote good behavior, they did it intending to provide life tenure?
Yes.
Are you aware that the terms of our justices at this moment are on average almost 10 years longer than the original justices' terms?
I think that's what we've talked about, and it depends where you draw the line, but yes.
And given this change in the world, can we still assume the framers' intent over 200 years later?
Yes, and I think, the framers did set up the system to operate in a certain way, and that's the way it continues to operate.
and you believe that we should do anything that we can assume the original framers to have intended.
I think that is probably an oversimplification of how, original understanding plays into this. But a big part of understanding what the Constitution means is what the people who wrote it think it means.
Is the Constitution a living, breathing document and therefore up to interpretation and amendment?
That is a big question. I'm not going to answer that with a yes or no.
That's fair. I completely accept that. Would a majority of the American population agree with setting term limits for justices?
It sounds like there have been some surveys that I'm not totally familiar with, but it sounds like it's certainly possible.
And would a majority of judicial scholars approve of setting term limits for justices as well?
I'm not sure, but I do know that the committee I worked with that I helped prepare the report for, I know that included a lot of scholars and a lot of really prominent Supreme Court lawyers, and they were pretty divided over whether this was a good idea or not. But they were unanimous on the fact that it would require an amendment to the Constitution.
And regardless of your personal experiences, do you have any knowledge on what the overall opinions of judicial scholars is?
I don't know.
Are you aware that no large democracy in the world still employs lifetime tenures for justices?
That's what it sounds like some folks have said today.
Yes. Are you aware that while some were originally built with lifetime tenures, they amended their plans after tenures ran too long?
Certainly possible, yeah.
And given everything I have asked you today and everything you have heard, do you still believe that America should deviate from how all other judiciaries are operated, and indeed how our own state's judiciaries are operated, in favor of the status quo?
I think the Constitution has served us well thus far. No one thought this country would live as long as it did, and here we are. I think there's no reason to really dismantle the whole system. When this frustration isn't aimed at the court, it's aimed at a different body of the government.
Thank you, Ms. Grammel. Those are all the questions I have for you today.
Thank you, Ms. Grammel. You may be seated now. Cross-examination of the negative counsel's witnesses has now concluded. We will now begin our closing arguments. First, with the negative counsel. Mr. Duckers.
Thank you, Your Honor. Before I start, hold the clock here. Got another $5 for you. I just want to say, and I know I speak on behalf of my dear friend Pedro, how proud I am to be associated with these fine young people. Nathan and Caitlin, Sarah and Riley. They did an absolutely outstanding job, but they caused me a problem because I was going to have some unkind words to say about people who think youth and inexperience is better than age and wisdom, and they've really made that a lot harder for me to argue. Before I start, I want to have a show of hands. How many people in this audience would like to see at least one current Supreme Court justice replaced? All right. That's all we're going to say about Mr. Cordoba's public opinion polls about people supporting term limits, because I'm surprised it's not 100%, because literally every single person knows of one.
The time should be running. What are you doing?
Pay no attention to that man behind the curtain.
The time should be running.
Time is running. It is running.
Well, it is now.
All right, that took about 10 seconds. The point being that people support term limits because there's someone they want to get rid of, which is what this argument is all about here. What I want to do is talk about what this proposal is about and what it is not about. It's certainly not about improving the quality and jurisprudence of the Supreme Court. I guarantee you there is not a single person at the Brennan Center for Justice who thinks the world would be better or the Supreme Court would have been better if Justice Brennan was termed out of office and he wouldn't have been replaced by Gerald Ford. Under your proposal, he would have been replaced by Richard Nixon. Nobody thinks that's a good idea. And nobody thinks that you're going to improve the quality of judges by getting rid of experience and wisdom and moderation and replacing it with inexperienced ideologues, which is precisely what this proposal is going to encourage. And as I suggested in my opening, you need to look no further than the Dobbs decision to see how that plays out. This is not about improving the judiciary. It's also not about eliminating strategic political behavior and strategic retirements. I'm baffled by that argument. I only heard one example offered of strategic retirements, and that was Anthony Kennedy. And that's not a strategic retirement. Anthony Kennedy was the key swing vote in upholding Roe versus Wade and upholding Casey. He was the author of Obergefell, right, on gay and lesbian rights. And he retired during Donald Trump's term. Donald Trump, who ran on overturning Roe versus Wade and ran on a bigoted platform that was anti-gay rights. You cannot say Anthony Kennedy was a strategic retirement. On the contrary, he is yet another example of the fact that there aren't strategic retirements. Justice Blackmun, Justice Souter, and Justice Stevens were all nominated by Republican presidents and all recently retired with Democrats in office, with their successor appointed by a Democrat. This argument about strategic retirements is a red herring. What it really reflects is concern about about the lack of a strategic retirement. People are concerned and they are upset that Ruth Bader Ginsburg misperceived her own mortality and didn't retire during Barack Obama's term. And she instead stayed on and passed away during Donald Trump's term. She should have strategically retired. But you can't make this argument that you're going to eliminate strategic retirements, and you wouldn't do it anyway. In fact, you would make it worse, because it's kind of interesting, but uncertainty breeds caution. Uncertainty breeds moderation. Certainty allows for extreme behavior. As it exists now, you don't know who's going to replace you if you retire or how it's going to play out, but put in place this scheme that Mr. Cordoba outlined, and you'll know for a fact that if you retire or don't appoint a new justice, you're going to pull someone in from the bullpen, one of these inactive justices. So rather than having a couple liberals on the court, we'll just keep Clarence Thomas and John Roberts on the court. This is certainly not a proposal, in my view, about improving public perception or the court's legitimacy. You know, today you may not like decisions. You may not like what Mitch McConnell has done in terms of the advice and consent process. You may not regard the court as being quite as independent as it would. But this is a proposal that literally says we're going to give every single president an opportunity to appoint two partisan hacks, because that's what they're going to be. And we're going to try to ramrod it through the Senate and revise the advice and consent formula. That's not going to improve the judiciary. It's not going to improve public perception. What this proposal is entirely about is dissatisfaction with the current composition of the court. And when I heard this testimony about how senators will be more responsible in acting if it's not life tenure, nonsense. Senators can't see past the end of their nose for the most part. They're voting now on justices who are going to decide decisions today and tomorrow. They're not worried about and they're worried about their own election in 4 to 6 years, but they're not worried about what some justice is going to do between his 18th and 36th year on the court. Am I out of time, Raina? So I got the red card. Thank you all so much for attending tonight. I hope you enjoyed the show, and I hope you will reject this proposition. And as I said at the outset, you want this to be a constitutional amendment. You don't want Congress changing this every 4 years.
Thank you, Mr. Duckers. Mr. Irigonegaray, you may now begin your closing argument for the affirmative
before
counsel.
I start, I like the same privilege. Although I'm obviously teasing with my dear friend Ed, I too want to express the immense gratitude that I have for my co-counsel. These two ladies have worked really, really hard, as have the counselors with Ed. They deserve a great deal of credit. They took an issue, they have worked with our experts, with Steve, with you, with Mike, with Lou. It's been a great pleasure. And I want to thank Audrey and Sarah and everyone here at the Dole Institute for allowing us to present this program to you. Now you may start. May it please the court, counsel. I've often heard the immense respect we should pay the founding fathers, as though they were infallible. Well, they weren't. I wonder if there would have been a black founding father, whether our Constitution would have described a black person as less than a human being. I wonder if there was a woman as a founding mother, if we would have not taken until the 20th century for the women in this room to have the right to vote. So this assertion that somehow these founding individuals have the magical answer is absolutely preposterous. The Constitution is a living document. The Constitution should reflect where we are in society today. The idea that a Supreme Court justice should sit for 35 years, 9 presidencies, does not make sense in modern society. The idea that we would be losing this immense amount of intelligence, experience. We have thousands of young, competent lawyers. Look at these folks. Look at these people. Why shouldn't they be given an opportunity to determine the rule of the law, the rule of our nation? Why should we allow, when no other democracy has the life term, for us to follow that example, which is antiquated? It does not work. The opposition presents to you chaos would be the result. Oh, you don't want to do that. My gosh, it's going to be nothing but chaos. Why? I trust the American public. Don't we choose the president, our legislators? And you know, term limits work well. Our Supreme Court in Kansas is the perfect example. At a certain age, our justices of the Supreme Court are automatically retired. Has that damaged the integrity of our court? Has that damaged the appointment system? It has not. We have an excellent Supreme Court. In fact, I wish our United States Supreme Court would be similar. The ethical issues that we have seen recently with the court, the only way that we could remove those justices is through the impeachment process. Basically an impossibility. I suggest that having an 18-year term, although we're going to lose from time to time excellent justices, that doesn't mean our nation doesn't have a great wealth of young people that can pick up the mantle, that can proceed with making intelligent, wise decisions. Mike, Lou, even this old guy here. There is a huge amount of talent in our nation to fulfill the job of a justice of the Supreme Court, and the proposal we're making is commensurate with the democratic process. It's commensurate with keeping in tune with the times. It's commensurate with giving opportunities. It's commensurate with the rest of the world that has recognized the importance of term limits with individuals that have such immense power. The world is not going to fall apart, ladies and gentlemen, if we have term limits. Our world would be better. Thank you for your attention. I'm very appreciative of your presence. Thank you, Ed, and thank you all for being here. Should we bow?
We should bow.